Got a question asking if a landlord can take over after a landlord or a property manager serves a 3-day notice or whatever termination notice it is without losing that much time. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, subscribe to our videos. Now, we get this question quite a lot. We do have property managers and landlords that do serve their own notices, and they want us to take over the case, to move it through the court system, okay? Because most landlords or people, they understand that first we have to serve some type of notice. It's usually like a 3-day notice to pay rent, or we might have to serve a 60-day notice to termination of tenancy, to end a month-to-month tenancy, that type of deal. And the number one question we get is, hey, I want to file at the courthouse as soon as possible. I go, okay. The answer to this question is yeah. A landlord definitely can take over from a landlord's termination notice. The biggest problem that I see with landlords, and like just had this happen last week, is notices are not legally sufficient. One of the things that your lawyer is going to do, and including my office, is when you do your own termination notice, whether it's a 3-day notice to pay rent, a 30, 60, 90-day notice of termination of tenancy, there's a lot of things that this lawyer is going to have to do, including figuring out if your notice is in compliance with basic termination of tenancy laws, such as, Code of Civil Procedure Section 1161 governs 3-day notices, your 3-day notices to pay rent, for, fixing material violations of a lease agreement, that type of deal, or your termination notices subject to Civil Code Section 1946, actually, and there are certain requirements that to terminate a month-to-month tenancy or week-to-week or periodic tenancy, you have to provide certain things to your tenants, or disclosures, that type of deal. And that's kind of where we see the delay in things, is the landlord doesn't have the language in the proper format, or they have a proper form notice, but they don't fill it out completely. Biggest mistakes I see landlords do are like with 3-day notices for rent, instead of putting the name, telephone number, and the address of the person where rent's to be delivered to, the landlord will screw this up in various forms. They may put the rental address in where tenants can pay rent because they don't want to disclose the address. They may put someone else's phone number on the notice, like the senior property manager, who is not the designated person on the 3-day notice to pay rent to. It's just little things like that will slow down the case, but a lawyer can take over the case if the notice is served properly without any issues. We do it all the time. I have property managers that know the rules, they know how to serve things, they get it done. All they do is give me the notice, I go file in court, okay? The biggest mistakes are the landlords themselves just not serving notices or having the requisite language on the notice, and that ends up being either we have to take over, or that landlord's going to have to serve another notice and go through the process again before we can go to court. So landlords, property managers, if you're in the Northern California area and you need to evict a tenant, whether it's for non-payment of rent or for some type of lease violation or terminating a tenancy, feel free to reach out to us on our website below and book a free case review section. There's some questions that we'll ask, that will be asked of you to see if we're a right fit for our office. And if you have comments, questions down below, put them down below. I'll try to answer them to the best of my ability. Until next time, folks, I'll talk to you then. Thanks.